A major legal blow to the Trump administration's immigration enforcement strategy has just landed. A federal judge ruled that tying Federal Emergency Management Agency (FEMA) grants to states' cooperation with immigration authorities is unconstitutional, a decision that could reshape the ongoing battle between federal and state powers over sanctuary policies. But here's where it gets controversial. The ruling doesn't just stop the Trump administration's punitive tactics. It raises bigger questions about the limits of federal leverage in emergencies. And this is the part most people miss. The judge's 45-page opinion frames this as more than a political dispute. It's a clash over constitutional principles and the very idea of what federalism means in a crisis. The case centered on 20 Democratic-led states, including California, New York, and Illinois, that sued the Trump administration over a Department of Homeland Security (DHS) directive. This document, released earlier this year, threatened to withhold FEMA disaster grants from states that refuse to comply with immigration enforcement requests. The states argued this was tantamount to holding critical emergency funding hostage, as U.S. District Judge William Smith of Rhode Island put it in his ruling. They claimed the policy violated federal law and could cost them billions in disaster response funds, jeopardizing public safety during hurricanes, wildfires, or other emergencies. The Trump administration pushed back, insisting its policy was lawful, and even claiming months later that it had softened its stance. Officials told the court they'd decided not to link most FEMA grants to immigration cooperation after all, calling the lawsuit moot. But the states called this move half-hearted and incomplete, pointing out the lack of clarity about whether the reversal applied beyond 2025, or if it had been properly communicated to federal staff. Plaintiff states stand to suffer irreparable harm, Judge Smith wrote, noting that losing emergency funds cannot be recovered later and would harm disaster response and community trust. This ruling follows a months-long campaign by President Trump to penalize sanctuary jurisdictions, cities and states that limit police cooperation with Immigration and Customs Enforcement, ICE. The administration argues these policies hinder ICE's ability to detain undocumented immigrants, including those with criminal records. Sanctuary advocates, however, counter that such cooperation erodes trust between immigrant communities and local law enforcement, discouraging crime reporting and community engagement. Here's the twist, Smith's ruling suggests. Forcing states to choose between emergency funding and immigration enforcement may violate the Constitution's separation of powers and the principle of state autonomy. The controversy isn't just legal. It's deeply political. The Trump administration has used executive orders and agency rules to cut off funding to sanctuary jurisdictions, with the Department of Justice and HUD already implementing similar policies. Democratic cities like Los Angeles, Chicago, and Boston have faced lawsuits in response, with a San Francisco judge recently blocking funding cuts to 36 jurisdictions. Now, this latest ruling adds another layer to the debate. Is it fair to use emergency funds as leverage for immigration enforcement? Or does it create a dangerous precedent where federal agencies can coerce states into policies they disagree with? As the Trump administration prepares to appeal, one question lingers. Should disaster preparedness, meant to protect everyone, be weaponized in ideological battles? Share your thoughts in the comments. Does this ruling protect state rights, or does it weaken federal efforts to secure borders? And if you were a policymaker, would you prioritize funding for emergencies, or insist on cooperation with immigration enforcement? The answer might define the future of federal-state relations for years to come.